Questions?
Mr. Chairman.
Representative Barbieri.
Thank you, Mr. Chairman.
Here come the lawyers.
So, Representative, at what point in the legal process is this defense available? Can a defendant come into a court without an attorney and successfully use this defense to get a case dismissed?
Mr. Chairman, thank you. Thank you for the question, Representative Barbieri. Well, under this provision, any action would proceed under the Idaho Human Rights Commission, which provides robust protections. There would be layers you'd have to go to before you'd end up in court. There'd be the mediation. And at the first instance, the defendant could put forth that defense and say, as applied to me, this is frivolous. This is, I'm just one baker. There are 50 bakers within a block of here. And so this is not the least restrictive means of pursuing the compelling interest of preventing discrimination. So they could head this off at the pass very early. And again, this has been presented in actions, and it could be one of the reasons why there has never been an explosion of litigation despite 46 years of this statute.
Follow up, Mr. Chairman.
Representative Barbieri.
Is an individual supplied an advocate in this situation, or must they research the law themselves and come up with this defense affirmatively in whatever commission you're talking about?
Well, they wouldn't be supplied a government, the initial step, my understanding is nobody has an attorney. The initial step in the mediation, people are representing themselves. They could hire an attorney if they wanted to, but nobody's provided with a government-funded lawyer as their advocate in the first stage. But I would defer to our Human Rights Commission for detailed questions on the procedure.
Thank you, Mr. Chairman.
Representative Luker.
Thank you, Mr. Chairman. And Representative Rubel, the defense that you're referring to is Idaho's RFRA law, is that correct?
Mr. Chairman, I'm referring to the free exercise of religion protected provision.
Yes, Title 73.
Yep.
And are you familiar with the Elaine photography case out of New Mexico that rejected the very similar provision because it only applied to government action and not suits between individuals?
Mr. Chairman.
Rubel.
Mr. Chairman, I don't see any restriction in the Idaho provision that would prevent, in fact, it's quite explicit in our provision that it can be asserted as a defense in any action, whether brought by a government or an individual.
Representative Luker.
Mr. Chairman, Representative Rubel, it says in an action brought by a government, and that was the reason for House Bill 427 last year, is because of the absence of individual protection. The Idaho law mirrors New Mexico in that respect. And so I'm just asking if you had considered that case in your presentation today.
Mr. Chairman, I haven't done a direct comparison of the language, but I have looked at the language of the Idaho Code, which indicates that a person whose religious exercise is burdened in violation of this section may assert that violation as a claim or defense in a judicial proceeding. So it doesn't indicate that that defense is limited to being asserted against the government. And my understanding is it has been asserted in claims brought before the Human Rights Commission.
Representative Luker.
Yeah, Mr. Chairman, Ms. Rubel, claims with the Human Rights Commission would be involving governmental action, but once it's past that point, if you have a right to sue letter, you're suing an individual as opposed to having the Human Rights Commission coming after you directly. And I would ask you to compare the two statutes, because the interpretation of the same language in the New Mexico case was held not to cover person-to-person suits, only government-to-person suits, and it's the same language. Thank you.
Thank you, Mr. Chairman.
Representative Jordan.
Thank you, Mr. Chairman. Representative Rubel, thank you for your testimony today. Can you dispel some fears with some concerns regarding the case in Coeur d'Alene and the hitching post?
Thank you, Mr. Chairman, Representative Jordan. That case ended up not getting off the ground because that organization was deemed to fall within the religious exemption. And so I think that was an example of the law operating as intended to ensure that that organization would not be subject to liability or to any of the existing laws.
Thank you.
Representative Andrus.
Thank you, Mr. Chairman and Representative Rebel. So are you telling us that if we pass this bill and it becomes law, that these situations that we've been talking about, the florist in Washington, the photographer in New Mexico, the baker in Colorado, that they will be protected in their right to not provide service to someone who requests it?
Thank you, Mr. Chairman. Representative Andrus, I can't represent to you that they would never face liability for their actions, but what I can represent is that they would have the same defenses that have been available to all florists, photographers, bakers for the 46 years in which this statute has been in effect and that have successfully prevented frivolous litigation and an undue burden. They would be able to assert the defense that they are being sued in violation of this provision, that they are being sued in a manner that is an overly restrictive imposition on their religious rights. And so to follow up, I mean, maybe the answer there is different depending on whether you're the only florist in a 100-mile radius or you're one of 50 florists on the block. And it would be up to courts and others as to how they construe that, but the defense would be available.
Representative Andrus.
Follow up. Thank you, Mr. Chairman. Representative Rebel. The bill we're considering on lines 18, 19, and 20 of the first page, I'd like to read part of that. Enjoyment of any accommodations, facilities, or privileges of any place of public resort, accommodation, assemblage, or amusement. Now, it seems to me that that's pretty broad. And people in private enterprise, as the examples that we've talked about, would still be liable and obligated to provide service. Can you help me with that?
Yes, Mr. Chairman, Representative Andrus. That would be the first line of liability, but this entire section would remain subject to that other statute and the existing statute. So the proposed House Bill 2 would remain subject to all of the other provisions in code, including the definition section of 5902, the religious exemption section of 5910, and the protection of the free exercise of religion section in 73402. So a person could come forth in the first instance and say, I think there's a violation of 5909 here, but then the defendant can come back and say, no, I fall within these other protections. And there's, depending on the merits of their case, there's a very good likelihood that they would prevail if they have a meritorious defense.
Representative Barbieri.
Thank you, Mr. Chairman. I love how we attorneys can have different opinions and argue them effectively. First issue I'm concerned with in terms of the Coeur d'Alene case is whether or not you're aware of how much it cost the NAPS to successfully defend that case.
Mr. Chairman, I'm not aware of their legal fees.
Secondly, if I may follow up, Mr. Chairman, as you were reading from the statute, you used the term judicial proceeding, and I find that kind of exclusive of the commission's proceeding. Are they one and the same, or is this defense only available in a judicial proceeding?
Mr. Chairman, Representative Barbieri, my understanding, and I would defer to those in the Human Rights Commission as to how they would apply it, but my understanding is that there would be an evaluation at that early stage of what the existing defenses are and what the existing causes of action are. And they would take into account the fact that there is a meritorious defense that could be asserted in a judicial proceeding. And they would say, gosh, looks like the plaintiff has a lousy case here. Why don't we call it a day?
Mr. Chairman, just a clarification. So you're talking about the commission then would make this determination?
Again, I would defer to them, but you typically, in the mediations I've been involved in, that's how mediations work. Everybody puts their best foot forward, explains what the parameters of the case and the legal defenses are, and you arrive at what you think the most likely outcome would be.
Mr. Chairman, if I may just clarify, just one more question. So we're parsing this out now, and so we're being a little broad where we need to be broad and specific where we need to be specific. The question is, who is advocating for the defense? Are you suggesting that the commission takes upon itself the advocate of the defense and saying, well, the defense could, therefore, without the defense bringing any of these items up themselves, the commission themselves would say, well, let's look at the defense. They would have all of these legal defenses available to them if they went to a judicial proceeding, so let's look at that and examine that. Therefore, basically, they have their own advocate. The defense would have their own advocate within the commission. Is that what you're suggesting?
Mr. Chairman, I think typically a defendant would put forth their best arguments in their own defense in the course of all of this, and that would be taken into account. And a good mediator would also look at all the arguments on either side and, may bring their own wisdom and knowledge into the matter as well.
I'm sorry, Mr. Chairman. One more follow-up.
Should be.
She is bringing these issues up and raising new ones, so if you don't mind, Mr. Chairman, just one more follow-up. So what I'm trying to get at, Representative, is that if the defendant doesn't know specifically of their defenses, and you talk about mediation, mediation requires an advocate, which requires hiring an attorney, which requires funds. And this is what I'm trying to get to, is the costs. So when we bounce back and forth between representing ourselves in front of the commission and representing ourselves in front of a mediator, or having representation in front of a mediator, the question I'm trying to get to here is, at what point does the defendant have to hire counsel so that they can advocate the proper legal defenses?
Representative Bell.
Mr. Chairman, I apologize, I wasn't intending
That's a
to
really
bring a
easy
new.
question, I'm sure.
Yes. Well, it's always the case that, we offer defenses in the law, and it's always the case that a defendant may not know what they are and may not end up asserting them. But I don't know that that means that the law is faulty. If we have offered up the defenses available to people, that's kind of the best we can do, and they've kind of got to find those defenses and assert them. And presumably the mediators are aware of those defenses too, and may volunteer that information. But typically in all other areas of the law, we kind of leave defendants, up to figure out what their defenses are.
For some reason or other, that doesn't give some of us much comfort. Representative Wintrow.
Mr. Chair, Representative
Gone on
Bell.
just about long enough about the legal arguments, but
I just have a question.
quick.
Representative Rubel, and maybe this is for the chair, actually. When we are considering legislation, in particular about the rights of human beings, is it normal to consider the costs of litigation of somebody that might have to file a suit if they are wrongly terminated or fired? You see what I'm saying? Maybe that's a question for the chair.
If you're asking the chair, I think it is appropriate to weigh that as part of the legislative process, because I, for one, don't think that it's appropriate that government's heavy-handed, and particularly when in government actions, that they have the deep pocket, and I don't think that it's fair that individuals who are in that kind of a situation, that they ought to have to reach into their smaller resources and try to address those things. So I think it's absolutely a thing that the legislature should consider in passing this kind of legislation.
Follow-up.
Representative Wintrow.
I was mostly kidding. Follow-up to Representative Rubel, the question I posed, what do you think about that as well? Again, I'm new to the legislature, but I'm just curious about whether that is a
Here
concern
again,
that we typically...
That's not a fair question to ask an attorney, because they have a vested interest in this.
If I may, Mr.
Okay, wait, I have a better question then, Mr. Chair. Mr. Chair, thank you, Mr. Chair, Representative Rubel. Have you ever turned down cases as an attorney?
Mr. Chairman, yes, I have.
Follow-up.
Representative Wintrow.
Is it common that is it not true that attorneys examine the merits of the case and before taking the case, examine whether it's a good case and able to be proven, because you're going to have to charge the client, and could the client actually pay for that service? Is it not true that many attorneys actually decline cases because there isn't ample evidence to prove it in court and it's a bad case?
Yes. Yes.
Is that it?
Thank you.
Representative Luker.
Thank you, Mr. Chairman and
I know we shouldn't have started this.
I just wanted to follow up on the Human Rights Commission procedure that may be a little unclear at this point. It's my understanding that when a complaint is filed, then the commission receives it, and then they review it and notify the defendant who has to respond. If they don't respond, or if the negotiations fail to result in a resolution, then the plaintiff gets what's called a right to sue letter, and then they can go sue the person in court. Is that your understanding?
My understanding is there is a default provision, as there is with most laws, if a person doesn't respond. Usually there's some mechanism for a default ruling.
And follow up, Mr. Chairman.
Representative Luker.
Representative, you mentioned mediation, and a true mediator is supposed to be neutral. Is that your understanding?
Yes.
And, Mr. Chairman, Representative
Luker.
Bell, if a mediator is truly neutral, then they will not be suggesting either causes of action or defenses to the parties, but they will be communicating between the parties. Is that your understanding of a mediator?
Representative Rubel.
Thank you, Mr. Chairman. I've been through a lot of mediations, and I've had a lot of mediators suggest, hey, you may want to settle this case because this, that, or the other thing could happen to your case. So I think mediators will very often nudge people towards a resolution by bringing up the prospect of the other side's defenses.
Follow up, Mr. Chairman.
Representative Luker.
Thank you, Mr. Chairman. Representative Rubel. Well, regardless of whether a mediator violates their neutrality or not, by making suggestions, it's certainly possible that somebody would not be aware of this defense, but let's assume that they are, and they still are not satisfied with being sued, and they would rather stand their ground and say, you know, I didn't commit a violation. And then the right to sue letter is issued, and so they get sued. And I'd like to go back to 73402, which was the language that we were talking about before. And in subsection 4, you read the first part that said, a person whose religious exercise is burdened in violation of this section may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief against a government. It doesn't say against an individual, it says appropriate relief against a government. And that's the point I was making before, is that in New Mexico, the appellate court said in a suit between individuals, this provision did not apply because it was not a suit, was not relief against a government. It was seeking relief against a complaint by an individual. And so I'm just asking if you you may want to take a look at that language and the New Mexico court decision and how they interpreted that, because that's the same language that they used in New Mexico to deny the application of this defense.
Thank you, Mr. Chairman. I would read that to say that you can only recover, you can only obtain relief, and you can only recover your attorney's fees and costs from the government, but I don't see any restriction in there as to your ability to assert the defense in any judicial proceeding.
I'm not going to ask if there's further questions.
Well,
Representative Luker.
yeah, Mr. Chairman, just to indicate that I'm just reporting what the New Mexico court did with this language.
Yeah.
Thank you.
Thank you very much, Mr. Chairman, and good luck with resolving all this.
You know, the witching hour isn't very far ahead, and we've got a long way to go. Wayne Hoffman. Followed by Carrie Wilson, Patrick Chapman, Brian Redmond, Let's go to that point.